Well, I'll just say, you love him despite. How about that? Can I say that? Can I add a conjunction?
Well, I think this is probably a communist design.
Among other things, right?
Yeah.
Among his many manias, he designed some golf courses. I did not know that.
Okay. Right. Okay, before we start...
I mean, I'm sorry.
Before we start, just a couple of announcements. So anyone who's here for CLE credit, you need to sign on the dotted line outside. So if you're here for if you would like CLE credits, you need to sign before, and you need to sign after. To our panel on whither the death penalty. We're extraordinarily fortunate at Columbia to have had this long series that's been ongoing this month with the exhibit outside on Death Row with Death Row art, and it's been curated and presented, and the whole series has been given to us by Professor Jeff Fagan and Ellen Chapnick, and so we owe them a great deal of gratitude. Today, what we're going to be doing is we're going to be looking at where the death penalty is headed, basically. And we have an extraordinary panel with us this evening. Includes Maya Foya, who's the Reprieve director, George Kendall, who's been litigating for over almost 4 decades, and is at Squire Sanders, Barry Scheck, who's co-director of the Innocence Project, Christina Swarns, who is now the attorney in charge at the Office of the Appellate Defender, and Julia Tarver-Mason Wood, who's a partner at Paul Weiss and has also litigated death penalty cases. I'm going to introduce each of them when I start asking them questions, actually, so you'll get to hear more about them as I introduce them. But I did want to kind of just jump into the stream of conversation because we've only got 2 hours together, and we've got an extraordinary panel, lots of questions about where the death penalty is headed. And so I thought we should just jump immediately into the questions. Now, so the first area that I wanted to explore has to do with an issue that has plagued, a problem that has plagued the death penalty in the United States since its inception, basically, since the inception of the United States, since the inception of the death penalty in the United States, and that's the problem of race. We've seen ebbs and flows. We've seen recent decisions from the United States Supreme Court, actually, in Batson case, where we've continued to see extraordinary and explicit problems of race in the administration of the death penalty. And so, fortunately, with us today, we have Christina Swarns, who's going to start us off with a few thoughts on where race and the death penalty are headed. Christina Swarns, as I said, is the attorney in charge at the Office of the Appellate Defender. Prior to that, she was the litigation director of the NAACP Legal Defense Fund. And in that capacity, she oversaw all of the economic justice, education, political participation, and criminal justice litigation. And while she was there, she served as counsel on a number of important cases, including in front of the United States Supreme Court, Buck versus Davis, which was a case that challenged the introduction of explicitly racially biased evidence at trial. Swarns was the only black woman to argue before the court in that term, and is among a handful of black women to have ever argued there. So I wanted to open it up by asking you really, what are the changes that we've seen of late? Because, I mean, really what we want to focus on this panel is kind of changes in contemporary changes in this context and what we imagine the future changes might be. What's going on with challenges based on racial discrimination and inequity?
Well, thank you for inviting me here to this conversation. So I think in order to answer that question, we have to go back a little bit in time and to understand how today is quite different from even the very recent past. Many of you may recall a lifetime ago when we had an African-American president, and the country wondered whether we had arrived in post-racial America, where the problems of racial discrimination had been solved and we no longer needed to have organizations like the NAACP Legal Defense Fund addressing and fighting issues of racial discrimination. In that time period, we saw the Supreme Court issue several opinions sort of on the issue of race, not in the death penalty, but sort of echoing that theme, right? You saw John Roberts, notably, his line in the Seattle school desegregation case saying, right, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race, right? You get this sort of flip line from Justice Roberts in the Parents Involved case in 2007. That's followed in 2013 by Justice Roberts again in the voting rights case, right? Shelby County versus Alabama, where the court, in an opinion he authors, strikes down the preclearance provision of the Voting Rights Act. And in this decision, Justice Roberts says, notwithstanding the fact that the United States Congress reviewed an extraordinary record documenting contemporaneous evidence of racial discrimination in voting, 50 years has passed and it's a new day. And so we no longer need to have this coverage provision in the Voting Rights Act because, it's a new day and those are things of the past. That's 2013. And then, frankly, the world changed, right? The entire world changed. That year, Trayvon Martin was killed George Zimmerman was acquitted for the killing of Trayvon Martin in Florida. That was followed in rapid succession by the murders of Eric Garner, of Michael Brown, of Akai Gurley, of Tamir Rice, and we can go on and on and on. And so then the question of whether race was continuing to be a relevant factor in American life, and more specifically in the administration of the criminal justice system, became beyond dispute, right? We saw, cities go up in flames, Americans across the country out in the streets protesting for equal justice for African Americans in the criminal justice system. So it was in that context that I litigated the Buck case. The Dwayne Buck case actually went up to the United States Supreme Court just in the midst of all of this going on, right? And for those of you that don't know, the Dwayne Buck case is about an expert that presents evidence a defense expert that presents evidence that Mr. Buck, who's African American, was more likely to be dangerous in the future because he was black. And so this is square on, right, what is happening out in the streets with the police, right? Black is dangerous is what's happening in the streets, and black is dangerous is what's happening in Dwayne Buck's case. So, this is a case that had gone to the Supreme Court in 2011 and was denied cert. And then we come back on the heels of all that had happened in the world, right? And cert is granted. I argue 10 days after the killing in Charlotte. And then, of course, in February of 2017, Justice Roberts issues a decision that is, surprising in many ways, right? We expected as counsel for Mr. Buck that if Justice Roberts wrote, he would write a super fact-bound, very tight decision which limited, any relief just to one person named Dwayne Buck who did this on this date. And he did. He tried to do that. But he really went further, right? He went further than he had to, I think. And I think that speaks to like a forced acknowledgement of how pervasive and real and powerful race continues to be as a corrupting force in the death penalty and criminal justice overall. What Justice Roberts writes in the Buck decision is that some toxins, he's speaking to race, are deadly in small doses. He says specifically that this stereotype of black men as dangerous is pervasive and long-standing, and played a toxic role in Mr. Buck's case. And then, of course, he goes on to say that as a society, we punish people for what they do, not who they are, right? So you see a pretty remarkable shift in Justice Roberts, which I attribute, to, I think, what became an undeniable reality, which is that race is playing a role in the administration of the death penalty. It's playing a pervasive role and in criminal justice overall, and that it can't be denied. We now had just this fall, right, this capital case out of Georgia, where you have the juror having used the N-word and saying he did not believe that black people had souls. Now, having been given a stay by the United States Supreme Court, we're hoping, we're waiting to see if they grant cert. But I think we're now in a position where arguments that had been advanced in the recent past about the irrelevance or the limited relevance of race are no longer tenable.
Mm-hmm. Thank you. And just quickly, how do you see it changing in the next 10 years or so? Do you think?
It's hard to say. I mean, I would say that right now, right, we've had Charlottesville, right? I mean, I think that we are in a moment in time where it's going to be very difficult for the courts to turn a blind eye to race and to the devastating power of race in criminal justice and sort of in our society. How far that goes, I don't know. I don't know.
Okay. All right. Let's talk next about kind of what it's actually like to be litigating these days in the trenches on the death penalty. We have some, interesting statistics about the fact that, although the death row has grown consistently over the past decades, we've seen executions kind of plateauing. We've seen reversals plateauing, in large part because actually the number of death sentences being meted out have changed. And all of this has been affected, of course, and the litigation has been affected deeply by changes such as the AEDPA, which radically restricted habeas corpus starting in 1996 and has changed the way that we litigate these cases. Fortunately, to talk about that this evening, we have with us George Kendall, who's been in the trenches litigating death penalty cases for almost 40 years. He now directs Squire Sanders' Public Service Initiative and co-teaches here at Columbia the externship on constitutional rights enforcement in capital, habeas, and prison cases. And so his team currently handles more than a dozen capital, innocence, and prison condition matters. And they also regularly assist colleagues with cases before the Supreme Court and appellate courts. And George has been representing folks since 1979, and he spent 5 years as a staff attorney at the ACLU 11th Circuit Death Penalty Project, and for 15 years he was at the NAACP Legal Defense Fund. So hardly anyone better who can kind of give us a view of the past and how it's changing. And the question really here is, how have capital litigation strategies changed over time, and where are they headed in terms of kind of the kinds of strategies that lawyers are actually using in these cases to try and fight the death penalty?
Well, I think, thank you, Bernard. The takeaway on this topic is that we are not where we need to be, but things have improved in 40 years. For the first 20 years when the death penalty came back online in the 70s, as Ron Tabak in this audience and others know, most of the people who were facing capital charges in this country had dreadful representation. That was not because a lot of those lawyers didn't want to do a good job. It was because they were told they'd get $500 for all the expenses in the case. They were told they'd be paid $1,000 for the entire case, even though they were in private practices and had a certain amount of money they had to make every month or go broke. And many, many people in this country, back in the 70s and 80s, when there was great enthusiasm for the death penalty, were selected for death and got death after just trials that are a disgrace. There's no other way to put it. Two of my favorite are two cases from Georgia where the lawyers who represented these young individuals who were charged with capital murder had not ever read the death statute, were putting their papers in their briefcase after the first phase of the trial was over. They didn't even know that there was a bifurcated proceeding and there was a second sentencing phase. Neither of those men got relief in the state courts. Those cases had to go for years and only got relief when they got into the federal court. Back then, there was great enthusiasm for the death penalty, and that's a very important point. Because prosecutors knew that if they wanted to be a judge someday, if they wanted to be in the legislature someday, if they wanted to be a governor someday, these were the kind of cases that would get their names in the paper. And so in some counties, prosecutors would stretch he'd say the generic murder. There's no such thing as a generic murder, but just an unaggravated murder to make it a death-eligible murder so they could seek the death penalty and get press. And so the interesting lawyering was not going on at the front end of the system because the lawyers didn't have the resources to do it. It was going on at the back end of the system in federal habeas corpus. Smaller group of people, and in those cases, lawyers who came in often as volunteers, often with no money, would show that had there been a real legal team in place at the trial, it would have been vastly different. That there were 20 mitigation witnesses to tell a very different story than what the jury heard. If the jury heard anything at all before they had to make that very important decision. There were major challenges to the death penalty. Two, the McCluskey case, which the late Dave Baldus and his colleagues, an extraordinary study that showed Georgia's statute was not filtering out arbitrary factors, including race, that race was continuing to play the role it had played for 200 years, that it was really influencing cases, particularly cases involving black defendants and white victims. The case went all the way to the Supreme Court, and on a bitter 5-4 decision, the majority said that showing was not sufficient to show violation of the Constitution. That decision has stopped all systemic race challenges to the death penalty to this day. But there were less ambitious retail challenges that were brought and won. Two in particular. One, in 2002, the court held that after wonderful lawyering, that people with mental disability would no longer be eligible for the death penalty. That affected a good number of people. And then 3 years later in Roper, the court held that juveniles would no longer be subject to the death penalty. I think we and 5 other countries in the world, it was a disgrace, we're still using the death penalty as juveniles. So what is it like now? What has changed? Big factor, far less enthusiasm for the death penalty. And what that means is far fewer numbers of cases. And that is very important. We cannot do death in volume. One of the reasons why you hear all these embarrassing stories from places like Texas, where you have sleeping lawyers, and in other places, is the system can't handle many of these cases before the wheels come off. So we're seeing far fewer cases where prosecutors are seriously seeking the death penalty. And because there's been some improvement in some places in indigent defense, now you're seeing some real representation in more of these jurisdictions than ever before. However, there are still some very serious problems with the representation. We had a case in our office. We had for 10 years one habeas corpus relief, went back for resentencing in Florida, 30-year-old case. I qualified under all the Florida standards to represent him and be paid. Our view was, this is not pro bono work. If you're going to seek the death penalty again, you're going to pay us. The court approved it, but there's actually an agency in Florida to govern capital representation. The agencies they opposed our appointment and compensation because I wasn't a member of the Florida Bar. They did. They objected to the experts we chose because they weren't based in Florida. Little did they know, all our witnesses were not in Florida. It was cheaper to use these experts. But I say that we tried that case in 2014 pro bono and paid for everything. So there's a lot of problems that still remain. Even in the federal system, when the Sarnaev case was going on in Boston, you want to talk about a hard case. That's a hard case. Judy Clark, it took Judy Clark a year to persuade the judge to appoint in David Bruck. Now, a judge, if you're a judge someday and you're presiding over a capital case, please say to the defense, you get whatever lawyer you want and can work with. Because Ron and others in this room know of, Christina knows of countless cases where judges in good faith had tried to build a defense team and they accidentally put a lawyer named McCoy and Hatfield on the defense team and there are problems. Judges can do many things in this country, they can't do that. But things have gotten better. What else has changed? Life without parole. Now all over the country there's life without parole. Before, when you went in to try to plea bargain a case, it was life with 7-year eligibility, and that's why a lot of cases went to death. Now with life without parole, the hard part about that is, for litigators, is to sit down with your client and say you have to accept death in prison without a fight. That is a very difficult conversation to have with clients. And some of these cases that you are seeing going to trial, they're going to trial because the lawyer has not been skillful enough to bring in the right people to help the client make this very, very difficult decision. And I think also because of the great work of the Innocence Project and others, jurors now see the system as much more fallible than any of us believed it was until all these exonerations started coming out. And I don't know I'll be interested in what Barry says, but I think a lot of people thought, well, we're going to hit a number and then that's it. They keep coming. There are a lot more there. And that troubles people, and the prosecutors know they've got to have an ironclad case if they're going to try to seek the death penalty. So what might happen? What are we looking at in the future? Real quickly, as far as a defense lawyer, the death penalty brand is a damaged brand. Prosecutors are not running for office on the death penalty anymore. In most states in this country, I don't care how red the state is, governors are not running and talking about their support for the death penalty. As long as that's the case, and as long as we're seeing more exonerations, I don't see these numbers up here. That is a remarkable drop from almost 300 death sentences to 30 death sentences. Remarkable. The country is walking away from the death penalty. I don't see those numbers going up unless crime rates go way up, which Jeff Fagan knows a lot about, or if we have more leadership that is dividing our country. We live in a very volatile country. There are not many countries that have all kinds of people here, and we're all trying to live together. It's very easy to exploit differences. God, we have that in our past. And if this becomes more dominant in the future, unfortunately, that is going to be a breeding ground for more racism and more use of the death penalty. But we're seeing hopeful signs. The Delaware Supreme Court of all places, struck down its death penalty last year after wonderful litigation. And at least for now, the legislature has not reinstituted that. Florida, the Florida Supreme Court, after the United States Supreme Court in Hearst struck down its statute, actually issued a second ruling that it made it much more difficult to death sentence people in Florida. Now, that was a state where if you got a 7-5 vote, 7 for death on death row. A lot of people on Florida's death row would not be on death row in any other state but for that. And now the Florida Supreme Court has said, you want to use the death penalty? Unanimous decision. That's going to cut the numbers down dramatically in Florida. So those are not federal courts ordering that. These are state courts, which is new and good to see. There might be some retail development too. Someday a court is going to accept the fact that if you're seriously mentally ill, then that is a bar on the death penalty. Haven't gotten there yet, but there's good litigation going on around the country, and that, I think, is going to happen. And there also might be a similar rule unless you are the intentional, purposeful shooter, if you're otherwise very involved in the crime but do not actually kill, there might also be a ban there. So on the whole, litigation, it's more encouraging because there are fewer cases, and we're not out of this woods yet, but we're heading in the right direction.
Thanks, George. And you also perfectly set up the next set of questions, which have to do, in fact, with the questions of innocence, actual innocence, and exonerations, and the rate of those continuing exonerations, and also not only the 159 death row exonerations by state, but also the importance of kind of science and DNA testing in showing actual innocence. And you can see it here in terms of kind of the percentage of cases, about 30% of cases in which at least false or misleading forensic evidence was a part of the death sentence and the exoneration. So fortunately, to talk about that with us today, we have Barry Scheck, who's a professor at Cardozo Law School, and as you know, the co-founder with Peter Neufeld of the Innocence Project. And they've been working, of course, on DNA, but also on other evidence and challenging other junk science, including arson, hair, etc. So in the 25 years of existence of the Innocence Project, 351 individuals have been exonerated in the United States through post-conviction DNA testing. Barry Scheck is also a partner in the law firm of Neufeld, Scheck and Bruston, which specializes in civil rights and constitutional litigation, and he's published extensively in these areas, including the book with Jim Dwyer and Peter Neufeld, Actual Innocence, When Justice Goes Wrong and How to Make It Right. So the question I wanted to ask you, Barry, was, so what are the changes in terms of science and technology? How are those kind of changes going to affect the death penalty over the coming years? And also, how is the issue of junk science going to affect the death penalty over the coming years? And new technologies as well. In other words, so we've now got a lot of data mining, reality mining, and is that going to have any impact on what's going to be happening with the death penalty over the next couple of decades?
Well, it will. I mean, a lot of people thought when we started doing DNA testing and it came into courts in 1989 that, wow, this is going to be great for the death penalty because we'll be able to prove that people are absolutely, without any question, guilty. And therefore, it'll be much easier to get death sentences. And let's be honest, our colleagues in the death penalty community were saying, I don't want any testing in my cases. You stay away, right? But in fact, exactly the opposite has happened because the issue has to do with the legitimacy of the system and the ability of our criminal justice system to make accurate and fair determinations. And what the DNA revolution, and it was a technological change, demonstrated is that this system, and people weren't paying attention, right, is terrible at making accurate determinations for all the reasons that we know about. Bad lawyers, police and prosecutors breaking the rules, witnesses who lie, false confessions, mistaken eyewitness identification, all of it, right? And what's been amazing is that as you go into court and you exonerate people with the DNA test, and it doesn't have to be a capital case, there are only 19 of those with DNA, right? All of a sudden, it calls into question all these other problems in the criminal justice system. And the Innocence Project and all the organizations in our Innocence Network have been focused on them, right? So I knew that something really big was going to happen with the death penalty very early in the game when I was watching The Practice. Probably all of you are too young to remember when David Kelly had this show on television about this law firm in Boston, and it had very high ratings, and they'd just come off NYPD Blue, and so I'm watching this guy, Bobby, whatever his last name was, giving a closing argument, right, in a case, a fictional case, and all of a sudden he says, there are 100, and I actually had talked to the writers, you know, about DNA and how it worked, and it was a 3-part series about a DNA exoneration, and all of a sudden he's getting up in front of the jury and saying, there are 168 people that were on death row who were exonerated with DNA tests, right? And there were like 4, you know, and it was 168 people that we gotten out. Maybe it was 7 or 8. But the key to it all was that people understandably and correctly conflated all these wrongful convictions with the inability of the system to get it right. And of course, in the cases that count most, capital cases, they began to see it. And so we were able to show that, remember, this is DNA, is science that the government spent millions to help develop, and it was transferred for medical and research purposes to the criminal justice system, and all of a sudden it began to expose all these errors. And it wasn't just that crime lab people couldn't get conventional serology right. It exposed that all these cases where they said, you know, this hair came from this person, and now it turns out that FBI agents actually got together and tried to figure out ways to make that sound, these matches, as though it was unique, right, and went beyond the bounds of science. And not too long ago, we actually got the FBI and the Justice Department to admit that in almost 90% of the cases where agents, examiners were looking at this, they were exceeding the bounds of science and exaggerating the significance of the matches, and they waived all procedural bars and said anytime an FBI agent testified, You can go back into court, and if you can get the hairs and do a mitochondrial DNA test, we'll pay for it. And then, of course, we have to go through the long march in the states because they trained all the state examiners, too. And then what about bullets? Composite bullet lead analysis, where a bullet is at a crime scene, but it's deformed, so they can't look at the striations on the bullet to do their traditional microscopic examination. The FBI realized that when their analysts came in and talked about the chemical composition of the bullets, they had a number of false assumptions, and the National Academy of Sciences said so, and they agreed. That was actually the first agreement we had with them. We'll go back. We'll say that we made errors in all these cases. They talked about the errors. They went back and tried to help, correct these the best you could. You can't find the evidence, can't find the lawyers, can't find anything. And they did that with the National Association of Criminal Defense Lawyers and the Innocence Project. I mean, it's pretty wild when we're signing agreements with them and they say, go do it. But it's worse than that, because now, starting in 2009, the National Academy of Sciences said, wait a second, the only validated forensic assay that we have in this business is DNA. It's the only one with a database. It's the only one where you can make a statement statistically that's sound. So all of a sudden, bullets, right, that you're looking at the striations under a microscope, not validated. Fingerprints, not really validated properly. You can't make good, accurate scientific statements. And forget about fiber, forget about bite marks, probably will never be validated. So in 2009, the FBI, the National Academy of Science, issued this blockbuster report about all the problems, all right? And the forensic science community, many of them really practitioners and not members of what you might call, in some ways, the mainstream or academic scientific community. The mainstream scientific community was stunned that people were coming into court and saying this bullet came from that gun, right, to the exclusion of all guns in the universe, and I have a 0 error rate, right? This fingerprint came from that person's hand, this partial print, to the exclusion of all people in the universe, and I have a 0 error rate. And the scientists said, this is insane, this is nonsense, it's all bad, fix it, get some money, do some real research. And that was in 2009. And the courts didn't know what to do with this, so they started issuing decisions like, oh, we'll let this person testify to a reasonable degree of ballistic certainty. What does that mean? To a reasonable degree of, fingerprint certainty. It was ridiculous, right? And so, again, when the Obama administration got into office, it wasn't even soon enough. We got funding for a National Commission on Forensic Science, an organization of scientific area committees. We tried to get the major scientific institutions of this country, like the National Academy of Science and the National Institute of Standards and Technology, which is a venerable organization that sets the weights and measures and has real scientists there, to actually get involved in improving forensic science. And that battle was going on. And then Mr. Trump was elected, and Mr. Sessions got into the Justice Department. Boom, National Commission gone, and the so-called OSAC is weakened. And must be honest with you, there is still a war going on. I mean, there are many scientists that got involved in this and are still appalled, by what's going on. We had scientists coming forward and saying, bite marks, nonsense. Yet no court yet has decided that it's nonsense. They go, so we've been admitting this for a long time. Some huge echo chamber. So what has happened next is that the president's science advisors issued this great report called the PCAST Report. And because what the 2009 NAS report didn't do was try to give the forensic science community a way to accurately talk about the error rates, right, of their disciplines. Because after all, to admit something is certainly in federal court under the Daubert standard, you're supposed to talk about your error rate. And doesn't it make sense if you're a juror and somebody's coming in with the forensic methodology, you want to know how often do you get it right and how often do you get it wrong? What's your false positive and false negative rate? One simple way, the PCAST report said, you could do this is what we call black box studies, right? You can take samples replicating casework, give it to your analysts, see how many times you get a false positive, see how many times you get a false negative. And when they started to do that for fingerprint analysts and even for ballistic analysts, all of a sudden it wasn't, we have a 0 error rate, this is unique. It was 1 in 300. They had real error rates here. And that makes a huge difference to jurors. And this affects people. So I'll quickly end up by telling you about Texas, right? So it turned out that I'm virtually a citizen of the state of Texas, because it turned out Peter and I divided up the states. I got Texas, all right? And the first time I came down there, we stayed in execution on the verge of it, because then Governor Bush realized he couldn't execute somebody without a DNA test that could prove innocence. Turned out it didn't work out well for us, but we were able to get a statute passed right after that that gave you post-conviction DNA testing and banned actually execution of the mentally retarded, and the Fair Defense Act, and all kinds of things. And then we were able to get an election, and this is, I think, very important for our future discussions. There was an election of an African-American defense attorney in Dallas, Texas in 2007, Craig Watkins, and nobody expected him to win. This is Henry Wade's, thin blue line district attorney's office, and we go in there and he creates a conviction integrity unit. Somebody from the Innocence Project in Texas takes it over. We all go down there, we look at all the cases, and we start knocking out exoneration after exoneration after exoneration. And then we get a conviction integrity unit in Harris County. And then we have one in Tarrant County. And then we start exonerating people all over the state, right? And all of a sudden, everything changes. We exonerated a guy named Michael Morton in Williamson County, Texas. I remember I went down there, my friend Jerry Goldstein said, "What's Williamson County like?" And he went like this. Right? That's how bad it was. And this guy was convicted of killing his wife, and he's exonerated, and we found the person who really committed the crime, and we wound up putting the prosecutor who hid exculpatory evidence in jail with the court of inquiry, and all of a sudden they passed the best discovery statute in the country. Instantaneously you get discovery online in Texas. They now will actually bring up on charges prosecutors who cheat and lie. This is Texas. We got all these statutes passed with a Tea Party legislator. And Rick Perry is signing these bills, okay? Now, I'm not saying everything's great in Texas, don't get me wrong. But you want to know why all those numbers go down? You already heard yesterday from Brandon Garrett about it's just a few counties in this country that produce death and overproduce death. Well, one of them was Harris County, and all over Texas, and everything is dropping there. And they have a forensic science commission that's the best in the country. And in that forensic science commission, we got a ruling that the arson evidence that convicted and put to death Cameron Todd Willingham was complete junk. And if you ask American citizens, and we've done public opinion polling this even in California during those referendums, and we've seen it, you ask Americans, has anybody been executed who was innocent in the United States? They say Cameron Todd Willingham, all right? Because the arson evidence, it wasn't a crime, right? And if you had asked all of us, and I'm sure Christina and George, you'll agree, right? Well, what's the case that's going to actually convince people that innocent people get executed in this country? You wouldn't have picked arson, right? You'd figure, well, we'd dig up some guy and we'd somehow be lucky enough to find the evidence and that would be it. No. And it's actually even more significant than that, because we've subsequently put out proof that's unassailable that the prosecutor made a deal with the jailhouse snitch and suborned perjury, essentially, and that's how he got convicted and executed, and that all should have been revealed before he was finally put to death. So what I'm trying to say to you is all these different forms of junk science and all these different ways to show the infirmities of the system has a tremendous depressing effect on people's trust in the system and their willingness to impose the ultimate punishment. I didn't get to the other stuff, but we'll get to it.
We'll talk about it later. Great. Thanks so much, Barry. Thanks. So with the numbers coming down in the U.S., we still, in the U.S., remain among a particular club of countries around the world who execute, not a particularly, well, in any event, there it is. So there are, and of course there are, there's growing across the globe, a growing trend and tendency towards abolitionism across the globe. And of course this then puts some pressure on the United States, or at least raises questions about how is the international dimension going to affect the future of the death penalty in the United States. And we're fortunate to have with us tonight to talk about that Maya Foa, who is director of Reprieve, bringing you in from London, right? Or about more or less, Geneva. Yeah. And so Reprieve is kind of strategically challenging human rights abuses, both in the death penalty context and also in the abuse of terrorism contexts as well. And Maya has conducted extensive advocacy for governments of Europe. She's also been an expert advisor to the European Commission. And CBS News describes Foya as, quote, the woman behind a shortage of execution drugs. And so she's been very much involved in tracing exactly how the drugs are ending up in American hands and raising questions about that and challenging it. So the question I want to ask you at a broad level really is how the international dimensions are likely to affect the death penalty going forward in the United States. And so what are the kind of globalizing effects on the U.S.? And then also if you can kind of bring in and weave in these issues of drugs, importation of drugs, and pharmaceuticals, that would be helpful as well. Thanks.
Sure, thanks. Yeah, so it's fascinating to think about the U.S. As an influencer on the rest of the world. You know, you saw that one. I love having the slide that shows that the U.S. is bedfellows with Saudi Arabia and North Korea and others. Because everybody hates it, because we're so much more civilized. And that actually gets to one of the key things about the way in which the death penalty is practiced here. There is a fascinating desire for it to be seen as a more modern and a more sophisticated death penalty than the death penalty by, you know, the guillotine or hanging or firing squad. And I think that goes to the point about using fake science, using the lethal injection as this modern, humane, clinical way to kill. It's much better than, you know, what they do in those other countries, in those dirty other countries where they're killing people and they don't have a good justice system and they have crap lawyers. We've got good lawyers, right? They're all good lawyers. Everybody gets paid. So it's all this sort of the facade of the sophisticated death penalty system is something that I think now we're seeing people cling to in a way that's actually sort of perplexing, and I think may indicate something of the fundamental ambivalence that we have. And I speak as an American, and then I get told off for that, but I am, and I pay taxes, not many. I work for a charity. But you know, when you're looking at the lethal injection, I'll go back to how we've got to where we are. But you're at this point in the U.S. where every single, you know, they used to just use 3 drugs to execute people, and the 3 drugs, many people will know this, but briefly, because it's interesting conceptually too. The 3 drugs are an anesthetic agent, a paralytic agent, and then a drug that stops the heart. That paralytic agent is purely cosmetic. So that again speaks to this idea that we just need to have a medical valve. We need to have a facade. Otherwise, we're not actually very comfortable with what we're really doing, which might look a bit bloody, which might make us feel like we are akin to some of those other people on the list. So they used to have these 3 drugs. Now they've got sort of 15, 16 or so, and then if you add in the paralytics, maybe 20 potential different drugs they could use and different variations on the lethal injection cocktail. And they have this large number of drugs because at a certain point in time, they were no longer able to get the traditional drugs, and then they moved to other drugs, then they weren't able to get those drugs. And they just keep shifting. And not only do these shifts create enormous difficulties for them in terms of botched executions. Lethal injection has always had botched executions, but we're seeing them more now because sometimes the paralytic is removed, because there's more media attention, because they're experimenting, and experimentation, these are humans, and they're not doctors, and they're not capable of doing this. So we're seeing a lot of these executions go wrong. We're also seeing stays of execution and moratoria in lots of states. And the point of that is not that that's not going to be the argument that wins the death penalty. It's going to be nothing to do with method, and indeed method questions are somewhat of a red herring. But the stays give the lawyers a chance to, more time, gives the people more time, the prisoners on death row more time, and the lawyers more time to build their case, to try and convince, whoever it is, whoever your jury is, to not kill the individual. So you've got moratoria, you've got states having to be confronted by serious botches. The cost of the death penalty has gone up. It's getting harder and harder. And then you've got this corporate angle as well, whereby every one of these medicines is made by companies. The reason the states can't get the drugs is because the companies don't want to sell them to prisons for use and executions. And why is that? Because they're healthcare companies, and they make medicines to save and improve the lives and health of patients. And that is just, it's always been the case that the pharmaceutical industry didn't want anything to do with the lethal injection. When it was first created, you had Abbott saying, please don't use our drugs in executions. Yeah, the state of Texas didn't listen, turns out. But and now, because of a series of things that bring in the global dimension, these companies have taken a much more aggressive stance. So from having simply issued a statement saying, please don't use them, but then once the product has been sold, anybody here, you're all, some law students, others lawyers, once you've sold a product to someone, it's going to be quite hard to get it back. Now, just a couple of months ago, we had McKesson, which is Fortune 500's 5th most successful US company, sue the state of Arkansas, which I believe is the second poorest state, over diverted medicines that they wanted to use in 8 executions that were scheduled within 10 days. It was going to be the largest mass execution for 50 years. That's huge. We always talk about how, capital punishment, in every country actually, it's this cheap, easy political fix, and if you can make it expensive, difficult, and a political nightmare, you are going to reduce executions, because it's actually just expedient to kill people. And the less expedient we make it, and the more we debunk all of the mythologies, and that everybody here on the panel is doing that, the harder it's going to be to continue to use it. So to go to the global, the US clearly has an impact in the rest of the world. Where, we work in, as Shazad, who I'm going to point to because I said I would do it, who is a colleague who runs a death penalty an organisation that works on death penalty and counterterrorism issues in Pakistan. And we find when we're talking about abolition and we're talking about counterterrorism indeed, people will point to the US and say, well, US still does it. I was in Malawi when Obama came in, everybody was celebrating. I was in Pakistan ahead of Trump, and everyone was saying, this is going to be terrible for us. Although I asked Shazad recently how people feel in Pakistan, and his response, I hope you don't mind me quoting, was, well, now they know what it's like to have a stupid leader, or something, some such, and somebody else, Anyway, so, but the impact, I think what wasn't considered by the US, and it's not that surprising, because we are insular sometimes, in outlook, and America is big, and there's lots of inward looking to be done. What wasn't considered, I think, was the international dimension that could be leveraged or that was implicated by globalization and the desire to use these medicines that are made by multinational corporations. So back in 2010, when I started doing this work on the lethal injection, we had got a call because there was due to be an execution in Arizona. A guy, Jeffrey Landrigan, was going to be executed. It was Dale Bache, who's a good friend, death penalty lawyer, who'd called up Clive, who was in Dorset, and he called the office in London. I was sitting in this corner of an office, and he said, look, we've just got the state. They had a bit of secrecy then. We have a lot of secrecy now. It's, again, part of the facade. Got to hide behind the secrecy to do the dirty dealing. But he called up Clive and said, look, we've just forced the state to tell us that where they got the first drug in the cocktail from. And they told us it was from a pharmacy in England. Can you try and find out anything about these drugs? So I was tasked with trying to understand and figure out where the drugs could have come from for an execution that night. And the pharmaceutical supply chain is super complicated and actually really interesting, but I'm not going to go into it because it's super geeky too. But it is, you immediately see all of the different parts, and within that first set of hours ahead of this execution, I had figured out that at least they weren't good drugs. They could have been veterinary, they were definitely not, as we then later learned, FDA approved. So they weren't supposed to be in the US. None of the drugs that could have gone from England, from a pharmacy, were good drugs. So we sent off, I did an affidavit, sent it out, and we got a stay. And the stay didn't last. It was another one of those stories, and woke up to the World Service saying, after a brief stay of execution, Jeffrey Landrigan had been executed. But in the following days, and it really was just a couple of days, it was, we figured out a bunch of things. One, the source manufacturer of these drugs was a company called Sandoz. They're Austrian. They had got their active ingredient from a German company, whose name I can't mention, but German company, Austrian company. It had been sent over to the UK. Link Pharmaceuticals was one company, repackaged by another one, Archimedes Pharmaceuticals, sent to what we later discovered was the back room of a driving school that was operating under the name Dream Pharma. This was the middleman who sold drugs to states across the US for 6 months until we found out about it. We went to court in the UK to get an export control in place. Within 2 weeks, I think we had got the UK government to capitulate, put the export control in place, so that stopped the flow of drugs. It didn't stop, because we hadn't known about it before, the drugs going over and contributing to at least one botched execution. And also a delightful anecdote where 2 correctional officials from California and Arizona were swapping drugs, and because the California folks couldn't get any more because of the export control, so they traveled over to Arizona and they picked up some sodium thiopental, Dream Pharma sodium thiopental from the driving school, took it all the way back up to California, up across wherever it is. And then wrote an email. This was in the days when they didn't realize that writing emails were foolish. And their email said, "Thanks so much, guys. You guys in AZ are real lifesavers. Buy you a beer when I next see you." So that was the start. And seeing the reason why I mentioned the sort of 3 different countries and then the US is because all of those companies operating in different jurisdictions have different interests, of course. And Europe is against the death penalty, we know that. But this wasn't just because of Europe's position. This was because the pharmaceutical industry said, we make medicines to save and improve the lives and health of patients. If you use them in executions, that's not just going to damage our reputation. It's fundamentally against our business interests. We suffer legal risks, we suffer commercial risks. They didn't want this. Having suddenly the US have to look outside its territory, I think it exposed them, but it also opened us up to these different creative legal strategies, which are legal, political, commercial. You use a lot of soft law, you use a lot of court of public opinion stuff, but there's suddenly this global playing field for the US death penalty. And I can tell you can pick any drug. I'll find a link to a company I know, and now we've got 40 plus. They don't have any options there apart from to push it underground, or move to another method, or stop executing people.
Right. Thank you so much, Maya. And so the last topic I wanted to put on the table has to do with the large problems that have plagued the death penalty for so many years in this country, and its legal representation. Inadequate funding of lawyer representation, inadequate training, and lawyers essentially are taking these cases who don't have the right backgrounds or tools to actually litigate these cases properly. Now, fortunately, on this topic, we have with us Julia Mason Tarver-Wood, who's a partner at Paul Weiss, and who's litigated many cases in civil, criminal, and corporate matters. She's also done extensive pro bono work on death penalty cases. She represented John Paul Penry in Texas in a famous case that you probably all know, Penry versus Texas, which dealt with issues of mental disability and how that plays both as an aggravating as a mitigating circumstance. She's also represented an ex-Alabama death row inmate who was a juvenile who's now serving life without parole, and they're challenging that as well. Julia's also been honored for her pro bono representation of Guantanamo detainees, and she's a graduate of Columbia Law School.
Indeed.
So welcome back.
Thank you very much.
So the question I really wanted to get to with you is, is, so we have this history, Ruth Bader Ginsburg, a former professor here, who says, people who are well represented at trial do not get the death penalty. And it raises these questions about, how is the representation changing? But particularly with a focus on what's going on with pro bono representation and what's going on with publicly funded capital defense. And how is that likely to change the direction of the death penalty in the future?
So first, thank you. It's great to be back here. I love coming back to Columbia as often as I can. It's one thing that you can find permeating the entire conversation, at least as I've been listening to all these fascinating speakers, I could listen to you guys forever, is the difference in public opinion. And when we talk about the death penalty in the United States, even though it is technically a law, as with most laws, but in particular this law, it is so completely, inextricably tied to public opinion. It is the most political. Criminal justice is obviously full of political debate, but the death penalty in America is probably the most politicized of all of our criminal justice policies, and perhaps rightly so. So I just wanted to talk for a minute about public opinion and where we are. The last two major studies that have been done, the Gallup poll back from October of last year, found that we are now at the lowest level of support in the United States for the death penalty than has been the case since 1972. So for the last 45 years, now the support for the death penalty is lower than it has ever been, literally in basically my entire lifetime. The support for the death penalty is now at 60%, but understand that is when you don't give options like life without parole and some of the things George was talking about that are very important to people making a decision about life or death in a particular case. But in addition to that, the people who actually oppose the death penalty is now also increasing. So you have the opponents of the death penalty increasing. You have people who say they're willing to support the death penalty coming down. And one obvious question that raises is, what does that do to juror qualification? As most of you may know, if you have strong views against the death penalty and you are unable to put those views aside in serving as a juror, then you're going to be excluded from a jury in which a potential death sentence may be meted out. And so there are real issues, I would suggest, that in Sixth Amendment rights when you look at this high degree of public opposition to the death penalty and the wholesale exclusion of those folks from the death penalty. But given that that's where we are in terms of public opinion, I think it is very interesting when you think about what we're doing for public representation, both by public institutions as well as by pro bono folks in terms of the death penalty. We are seeing, I think George was very right to call it a mixed bag. We certainly have had a lot of progress. And I think it really depends on what state in what particular part of the death penalty life cycle, if you'll forgive the oxymoron, that you're talking about. Obviously, we have made improvements in the type of counsel we are providing and the resources we are providing to counsel at the trial stage and at the direct appeal stage. Those are areas which are getting better and still in constant need of improvement. But when we talk about reversal rates in capital cases, you will see that the majority of reversals come not at that stage of the proceedings where right to counsel is absolutely guaranteed. Many of the reversals are coming in the later stage of the proceedings where your right to counsel or your right to capable counsel or your right to capable counsel with sufficient resources to actually make a difference is really a crapshoot, based in large part on the randomness of where you happen to be prosecuted and how that particular state funds or doesn't fund capital defense. So, there was a fantastic study that came out of Columbia, the law school, Jim Liebman and Jeffrey Fagan, that looked at these error rates and looked at the fact that 68% of individuals who get the death penalty for the time period that was studied, which was multi-decades, get reversed. In what other context do you have 68% error rate and people say, oh, yeah, we probably should do something about that? If we had 68% of airplanes crashing, as people are fond to say, or 68% of restaurants having botulism in their food, we would have a serious reform in our public thinking and in our policy approach. I'd like to say that the response has been commensurate with what that reversal rate would recommend. It hasn't, but yet it has been, I'm sure that that study and that phenomenon, coupled with the science that we're talking about, coupled with improvements in indigent defense, all of those things are contributing, along with the lethal injection issues, the climate outside of the United States, all those things are coming together. And I think we are seeing an environment where the number of capital defendants, as we see, is coming down. Fewer cases are being prosecuted. Even fewer cases are actually getting the death penalty. But then are we providing adequate lawyers at all stages of that life cycle? And that's really, I think, the fundamental question that we have going forward. And what is happening in terms of funding for indigent defense? We have to remember that, obviously, in these days where everybody's talking about budget line items, this is not a popular political platform. Even if you're against the death penalty, you're not necessarily excited to have your highest funding dollars going toward the support of an indigent capital defense program. That is never going to be a group that has lobbying support or strong lobbying support in Congress. That's not even a group that's enfranchised, right? That is people who, by definition, are reviled in the country and who it's very difficult to get a lot of public support for. And that's the kind of public support that you need for a lot of the very high-profile changes. Now, things can be taking place behind the scenes where, groups like the ABA have done a fantastic job of trying to promulgate basic competency standards that, these are basic things that have to be done in every capital case. These are basic requirements that every capital lawyer needs to adequately represent a capital defendant. But those are also slow moving. And again, the episodic application and the sort of freakishness with which some states are doing this and some states aren't. Some states give good representation at a given stage, but not another. There are plenty of states that have no state post-conviction representation whatsoever. And often it's, as I said earlier, it is that stage of the proceeding, after you've finished direct appeal, where you have a client who's facing an actual execution date and literally doesn't have a lawyer. I remember the time I got a call back in 99, 2000, and I heard that there was a whole slew, EJI in Alabama had a whole slew of Alabama inmates who were literally weeks away from an execution date without a lawyer. And, when you think about Gideon v. Wainwright and you think, it's important to have a lawyer at every critical stage of the proceeding, but somehow an execution is not considered a critical stage of the proceeding because it's game over at that point. But what we know from these cases is it takes that intensive multi-year work and investigation to build up the science, to look to see if there's actual evidence that we can test for DNA, to look at the what happened in the trial court and whether the trial lawyer was actually asleep or whether the trial lawyer was texting with the judge in the middle of the trial. All this sorts of information takes time to develop, and that's why these later stages of the proceeding where representation may be difficult to come by are so critical. In terms of actually where we are in the public representation, meaning representation by public officers of capital defendants versus pro bono representation by firms like Paul Weiss, I was actually curious to see that there's very little information. This will be a good study for somebody to take on or somebody to write a note on, so note to self. I don't know the answer about how in post-conviction proceedings, what's the percentage of capital defendants who are actually represented by a private law firm pro bono or a solo practitioner pro bono versus represented by some sort of state post-conviction agency. I would be curious to see that. But what I can tell you is, even though public opinion about the death penalty is at an all-time low, we have in recent years taken steps back in what I think is this bizarre association many in the country still have of associating what a lawyer does with what a lawyer's client has done or allegedly has done, right? We, if you look back, a very, very close friend of mine and someone who worked at LDF, Debo Adegble, was nominated by President Obama to be the Deputy Attorney General for Civil Rights. And Debo's a fantastic guy, not just because he's a good friend, but he has an illustrious career doing voting rights cases. He's argued before the Supreme Court multiple times. He was considered by most involved to be a perfect champion, a great appointee for that position, very inspiring life story. And you know what stopped him? LDF had represented Mumia Abdul-Jamal. So we're talking about a few years ago, a majority of the Senate, including some Democrats, and I can give you their names, voted against him because the organization he worked for, I don't even think Debo worked directly on the case, because the organization he worked for had defended a capital defendant and won relief from a court who found that the capital defendant was wrongly convicted. So he's not even defending someone who, bringing a frivolous claim. This is a claim that won in court. You have folks like Cully Stimson, who's, talking about the Gitmo lawyers, saying every law firm who does any Gitmo work, all your private clients need to boycott you. So I think there is an environment that's very insidious, that while at the same time we have a good public shift in the opinion about the death penalty, we have this difficult ability to remember the lessons of our forefathers like John Adams, that it is critical to our democracy that we actually represent people, even people who've been accused of horrible things. And that is one of the best things you can do to say you're a patriot, is to say that you believe in the rule of law so much that you're willing to represent someone, even someone who might be guilty of something horrible, because you believe that's the right thing. So, I guess that's a long-winded way of saying we've made a lot of progress, and I think most capital defendants are able to find lawyers now, and the question will be whether that continues or whether the pull of other high-priority pro bono matters, whether it's the travel ban or LGBT rights or all the other things, religious freedoms, all these other things right now that the country is worried about are pulling resources, particularly the resources of large firms like mine, in a million different directions. And so where goes the rest of the country goes the death penalty representation as well.
Thank you, Julia. That was really helpful to get a kind of broad picture of this, and also of the kind of prejudices that are implicated in representing these cases. All right, so quickly, what I'd like to do then is kind of pull back or go up 30,000 feet or something from all of these different issues, the international, the racial dimensions, the science dimensions, et cetera, and really ask the simple question of where do you think the death penalty is headed in this country? So many of us thought prior to the election that we were getting close to some kind of a constitutional decision that might strike down the death penalty. because of this waning of interest, because of the waning of sentences, et cetera, that there was a movement towards that. Some people had kind of written the blueprint for the decision that was going to come out of the United States Supreme Court. The whole books were written kind of, giving the blueprint in some sense. And of course, all of that has changed. So here we are in a kind of very different time. And I just want to get a quick sense from each of you before we open it up for questions and answers. A quick sense of what you think lies ahead for the death penalty in the United States. Maybe, Christina, why don't we come back to you first, since it's been a while since we've heard your voice.
Thank you. I think based on everything we've talked about, I think we still are in a good place to see the end of the death penalty. I don't know that we have 5 votes on the court at this moment. But I do think that for all of the reasons that we've talked about, sort of how the Innocence work has demonstrated the flaws in the system and how it's undermined confidence in the criminal justice system. Sort of the publicity around the flaws, right? The sleeping lawyer, the Dwayne Buck cases, the terrible injustices. There's so much lack of confidence sort of in the death penalty as a whole. And the cost of the death penalty, and sort of prosecutors being reluctant to pursue death sentences when you have life without parole as an option. I think you see it atrophying enough on the ground that I still think that I believe that trend is going to continue and that it's going to wane away regardless of whether or not we have a case go to the Supreme Court. I just don't think we have, I guess there are circumstances that we are currently faced with that could change that, but I don't think on the ground. I think there's enough support and there's been enough work on the ground that demonstrates that there really isn't enough will to pursue it sort of on the ground, even if there might be some will at the top.
George, what do you think?
I think DNA,
you want to make sure your mic is on? Is your mic on?
I think, unfortunately, the death penalty is in the DNA of our society and our culture. Most prosecutors during the last 40 years have never used a death penalty. Most prosecutors going forward will not use a death penalty. But it's always been there, and it has sort of this, there are people of good faith around this country who are prosecutors who think it's absolutely necessary to have it in their arsenal to fight crime and to put horrible, dangerous people in prison who've done terrible things. As long as Justice Kennedy is on the court, there will be petitions. They're going to the court regularly, take this case and strike it down. There are members of the court who understand there are moments in history for these kind of decisions, and there's some who feel that we are in that moment right now. We live in a very combustible society in the sense that, things can get out of hand very easily with the wrong kind of leadership. And so I think that I agree with Christina that if there's no new upset, if crime doesn't spike, if we're a stable society, there's going to be even less enthusiasm for this because we're seeing that you don't need it. So it doesn't play any legitimate role. The surveys of police officers say, what do you need to fight crime? And death penalty at the bottom, it's not at the top. It's an emotional thing. It's a symbolic thing. And so as long as things stay pretty stable, I think that this is going to continue to, the number of new death sentences are going down, but unfortunately at the same time the number of executions, despite Maya's great work and many lawyers at the back end work, there are like over 3,000 people on death row now, and many of them have run out of appeals. Most of those people would not be death sentenced if their crime was today. And I'll end by saying that what we're going to see is that states and individual cases and individual prosecutors are going to have to decide, do they want to see a person executed who they put on death row 20, 25, 30 years ago, who they wouldn't put on today? Are they going to intervene in that and slow that down? If that sort of stuff happens at the back end, that'll be a very telling sign that maybe this ought to be retired.
Thanks, George. Barry, what do you see?
Well, I remember when we were working for the moratorium on the death penalty in Illinois, which was a kind of seminal moment with Governor Ryan, that certainly from the point of view of those of us in the Innocence movement, The way we would argue about this was capital punishment might be an appropriate sanction for the most heinous of crimes, morally, right? I'm not going to have that argument with you. But you cannot, morally or in any other reasonable way, say that this system can get it right, okay? So that has been our strategy, a public safety strategy in some ways for a long time. And I think it's been successful in all the ways that we've discussed. But now, look, we were on the verge of getting this done if Secretary Clinton had won the election. The Glossop dissent was the blueprint for this, and that's over. Unless you can persuade me, unless you can do a good job on Justice Roberts, I don't know where we're going to get that vote if Kennedy retires in a year. So that is a problem. And I think that what we have to do, but it also might be an advantage. Because when you look at criminal justice reform generally in this country, and we're doing pretty well with that, by getting the right and the left together, we have the Koch brothers want to support indigent defense, and they're serious about it, and other issues. And we've made progress in, red states in a lot of ways, or like Texas. But the way you've got to do it, I think, is organizing from the ground up. That's what it takes. And we know that the death penalty is county-based. Jeff and Jim Liebman proved that with the Broken System article years ago. Brandon's recent book only demonstrates that again. But you have to go into these counties, these jurisdictions, deal with these elected prosecutors. And as Julia said, it is a political issue for them, right? There's always a danger when you have a lunatic in the White House that's race baiting and whipping all this up, that it could go bad in that way. But we have to struggle. And here's what disturbs me in that regard. Because I think we had a real opportunity 8 years ago for a referendum in California to get rid of the death penalty, okay? And it only got worse, and then we have Proposition 66, the speed up of the death penalty, which probably should be held unconstitutional, but that's insane when you actually look at that system. How did this happen? What was the problem? I'll tell you what the problem was. I think that we should go through the state of California, and no district attorney in a democratic, liberal state should get elected who isn't against the death penalty. It should be like abortion, right? And that is the only way we could end it in that state. And you can do it. You actually could do it using the same kind of strategies that Trump's trying to use with his 33%. You could do it. And we didn't do enough work, and we didn't get it done. And we were waiting for Jerry Brown to come down like a messiah and do this for us, and he's not going to do it. It's not going to happen. But we will probably get another governor that would help at least as much or more. And why doesn't Oregon get rid of the death penalty? Why doesn't the state of Washington get rid of the death penalty? There are other states, and if you get more and more of those by working from the ground up and doing criminal justice reform in lots of ways, I think that can work. But unless we're going to continue to do it in a very, very powerful way, don't think that this moment is going to last forever. Timing was everything, and I don't want to in any way underestimate the damage that was done by Trump's election and Gorsuch. I mean, that was very bad for this movement, and we have to really redouble our efforts to make sure that this scourge is ended, and that's what it is. It is a scourge.
Thanks, Barry. So, from across the pond, what's the view?
On both sides.
Maya.
Yeah. So I agree with everything that's been said. My strategy changed entirely with the election. I think I'm going to go for a sort of hypothetical. I think the Supreme Court solution, the idea that we would get that case was wonderful and everybody had a lot of hope. But actually, a lot of the work that a lot of us do is very state-based. So when you look at the method question, which is significant in that it can stop executions, and if you don't have executions for a period of time, you have a climate where you can abolish, because, as we've been saying, people get used to it. It's not anarchy. The world doesn't, the police don't need it. So what I am looking at, partly as a result of Glossip, this terrible case with one good opinion, is the alternative question. If states, and it could go different ways, but if states can't get the drugs, and if we get some states, a lot of them are having to contemplate alternative method bills. There's Oklahoma has lethal injection, and then it says in their execution statute, if that's not available or deemed unconstitutional, if you can't get the drugs, move to the firing squad. If that's not available or deemed unconstitutional, move to gas. If that's not available or deemed unconstitutional, move to the electric chair. It's just this menu of options. I think, and on the other hand, what you're seeing in some states which haven't passed alternative method bills, like Virginia, their legislature passed an electric chair bill. The governor vetoed it. He called it reprehensible. That's a very moralistic word. That's a very interesting word for a governor to have used. I wouldn't use it, and I am anti-death penalty. And he introduced secrecy law instead, which is it's problematic for all sorts of reasons, including for public health of his citizens, the corporate angle. There's all sorts of problems with it. That tension there, that Arkansas would rather be sued by McKesson than move to the firing squad, I think that's really, really telling. And I think it's telling because these decision makers are afraid, I think, on some level, and yes, some maybe won't be, but some are definitely afraid of what their public, their electorate will think if they do move to another method. If you do move to another method, the electric chair, there are legal challenges to it. The lethal injection has been hopeless. 1980, you can't litigate it. Well, it's extremely hard to win a lethal injection case. The bar is too high. So I think alternative methods, if it becomes more prevalent, if you have lots of different states doing different things, and I would be saying, I agree, I think we need to be a bit bullish right now, and I think as a community we need to grapple with that. There's a sort of call their bluff element of this. If different states do different things, some of them have moratoria that are long-standing. Nebraska abolished it. It was reversed, but they abolished having never managed to do one lethal injection execution because they couldn't get the drugs. If we can have more of that happening, then the death penalty is very unusual. Then it is cruel. Then you are back in that posture where maybe you can start to sort of play into the Glossip opinion rule book again. But we do need to seize that moment because it won't last.
Thanks, Maya. Julia, you get the last word on this.
Well,
what do you think?
I'd like to think I'm optimistic. I am certainly idealistic. I think that the studies will show that, as with many other hot-button political issues, it is very much dependent on your age, believe it or not. And so I think you're going to have a little bit of a positive effect just by the evolution of time. The Trop v. Dulles case, evolving standards of decency. They were onto something in the 50s when they realized that, generally speaking, we evolve in a positive direction. And at least for me as an abolitionist, that tells me that we are going to evolve eventually against the death penalty. That being said, I think George is absolutely right. It is a combustible situation, and it is very much susceptible to large things. I was very concerned about the Boston bombing and the Zarnev case and cases like it, because those types of cases, bad facts make bad law. And those are the perfect example. Death penalty cases are just exhibit A in that. And if you look back and see, it was literally Ted Bundy's case that first opened my eyes to the death penalty. Ted Bundy was being executed in Florida when I was a teenager in Alabama growing up. And I remember they were covering tailgate parties where everybody was serving barbecue and chanting Bundy barbecue, let's all... And they were literally having a party outside the prison because Ted Bundy, a serial killer, was finally being executed. While a part of me thinks, again, that that's abhorrent, I thought that in 1988 or whenever that happened, I don't think that's so unlikely to happen today if the right circumstances sparked it.
Mm-hmm, mm-hmm.
So I think it really just depends on the next generation of people keeping this momentum going and making sure that those standards do evolve.
Thanks. Maybe I'll just weigh in on this.
I think you're entitled
as well. Yeah. I mean, I've always been worried about the lethal injection effect as being easily reversible in some sense. I mean, so the effect on the rate of executions, the number of executions, the moratorium that has really kind of stopped it as a result of lethal injection is something that I've always been a little bit concerned that the time's going to run out on that and on lethal injection, and that we're not going to be seeing the same kind of reductions in numbers of executions as we've seen. So that trend kind of going back, but. And of course, the constitutional challenge now is really in peril. But it's really I think it's really this number that is the most striking, I think. The fact that there are only 30 death sentences in this country in 2015, I think that's really amazing. I mean, when I was down in Alabama, working down in the 1990s, that would have been Alabama, right? We'd have 30 people coming off or entering the row every year, and here this is for the whole country, right? I mean, that is really remarkable. And so what is it that's captured by that? And I think it's a lot of things. I mean, it's a lot of things, but I think it's also possibly different ways in which these cases are being litigated. Even at the trial level, possibly, it's the elimination of the death penalty at the margins for persons with mental retardation or for juveniles. It's the elimination of the judicial override in Alabama, which we just got rid of this year, and it's a constellation of factors that seem to be having this effect that is not reversible, I think, in the way that, say, executions could be reversible if they just decide to pull the switch on lethal injection. So it's something about the fact that there's just so many less of these cases coming into the pipeline. And it just feels as if, if you targeted the right counties and flooded them with, you, the extraordinary lawyers that are in this room, that could really take care of it, right? That really could take care of it. But we're here to also hear from you and your questions and your thoughts and your perspectives. There are many people in this room who have decades of experience in this. We're blessed to have such an audience with people who've been doing this work for such a long time. Ron Tabak and others, and students as well. So why don't we open it up to questions from the audience, views? Yes, start with this.
Thank you. Just picking up on some of the discussion we just had, interested in your thoughts and perspectives on the relationship between the innocence aspect of the abolition movement and those hard fact cases, the Tsarnaevs, the Dylann Roofs, the James Holmes, and it seems in some ways the innocence movement has created this notion of the death penalty is so flawed because it's hard to implement, but there still seems to be this room to sort of attack the death penalty per se and say, it's even taking a Tsarnaev or a James Holmes, these are people who don't deserve the death penalty or the death penalty should not be used in these cases. And so I'm just interested in your thoughts on how those two movements have possibly interacted in of late. Do you think the innocence movement has sort of created space to be making these moral arguments, or do you think in some ways it maybe can even make it harder when you're trying so hard to focus on the horrendous cases and maybe not talking about the ones that morally seem right for the death penalty?
Can I?
So yeah, I think this one kind of goes to Barry because it's really the double-edged sword of innocence, right?
Well, I think number one, you're right. It's created space to make the moral arguments. Number two, something I've been waiting to say, it wasn't my assigned area, but it's the last point you made. As an observer of capital lawyers over the last at least probably 25 years. And the ABA standards, Ron and everybody, has helped enormously. We know a lot more about how to try these cases than we did before. The evolution of teams, I think, was a major step forward. The Colorado method of jury selection, understanding how to try the case to those people that have, will actually hang the jury because of moral scruples about the death penalty, which is a very big deal. And as Julia's pointing out, you've got to be able to find them and keep them. Perhaps, George, you would know better than I, although I heard some stuff about it, if we'd had a fair jury selection in the Zarnev case, even that one might have hung up, all right? So I do think that there is a fundamental moral argument that goes to the core of what's good about this country and the empathy. We had a dinner, and that actress, Meryl Streep, who's been called overrated, said something very, very interesting. You remember how she criticized Trump for making fun of a journalist who had a disability. And what bothered her most about that is this man has no empathy. And what I heard her say at this dinner was, empathy is the centrifugal force that holds civilization together. And I think that's actually quite profound and true. So there are forces in motion in this country that are repulsed at what is going on, right? And I believe in them, all right? I believe in those basketball coaches that speak out. Listen to Popovich, he's the smartest guy in this country, on what to do, right? All of this makes a difference, and the way people are looking at the issue of race now, I think, can make an extraordinary difference. So I think you can get John Roberts' vote on this eventually. But I do think it's given space to make these arguments, and now we really have to make them from the ground up.
Yes, sir. I have a question. And why don't we why don't you introduce yourself too while you? We're at it, sir. Yes. Can you hit that little mic button on there, and then it turns red, and then you know you're on?
Hello?
There you go.
Hi, my name's Tom Ambrosio. I'm an attorney in New Jersey, and I'm on a CJA panel. And you made a comment, and I've handled a few death penalty cases. One of them went to trial in state court, and it was an acquittal. But I've had other ones where they ended up pleading out. And you made a comment that some attorneys are not convincing their clients to take life without parole. Do you feel that's always appropriate in every case where it's a death-eligible case and it's proceeding towards trial?
Let me answer it this way. I think that I have an obligation to I took the Hippocratic Oath, at first do no harm. If I have a client, and I've had very few clients who really, all of my clients have needed help in what to do. I don't break arms or kneecaps to get them to take pleas, but I try to make sure that they understand fully what they're looking at. Not simply that if we go to trial and take a risk and they pose a risk of being death sentenced, but to also try to really give them a lot of information about what kind of life they're going to have if they go on death row versus going into some other place in the prison. And I don't mean for the first 3 or 4 years, I mean for decades. Lawyers, or at least I can't do that by myself. Increasingly, we're using former people who are on death row to come in and help with that information. Ultimately, it's the client's decision as to what to do if there is a plea offer. But I think what a lot of lawyers don't do enough of, frankly, because they're not being paid enough or they're whatever, is you need to spend a lot of time to develop that trust, because this is the hardest decision that oftentimes this person has had to make, and oftentimes their loved ones who don't appreciate that and are, that are pushing people to do stuff. And so there's a lot of things you have to sort of deal with. But ultimately, I think that you can do everything right in a capital trial and lose. And so my view always has been, if you can get the deal, my stronger recommendation is to take the deal.
Yes. And just present yourself.
Hi, I'm Mary Marshall. I'm a student here at Columbia Law School. Thank you guys for coming. This has been really, really wonderful. My question is somewhat related to the LWOP comment. So I'm very opposed to the death penalty, but I'm opposed to it coming from a larger moral perspective of an opposition to our society's relationship with punishment more broadly. And so I was was struck both in the talk yesterday about the death penalty book and in this talk just about the role that this movement has to play in the broader conversation about reducing the amount that we use punishment in our country, especially when it comes to the fact that very frequently death penalty lawyers are asking their clients to take life without parole, which, while morally not quite as bad as the death penalty, I think is very, very troubling. So I'm just interested in your reaction to that and sort of broader comments on the way this movement plays a role in reducing punishment broadly.
Right. So, Julia.
I think that's a really interesting question, because consider myself very much a part of the death penalty movement, and yet I'm now challenging life without parole. So I don't think that just because I've, also encourage clients to take a deal that means they're going to be in prison forever when that's the right thing for them. That doesn't mean that you think life without parole is acceptable morally or even constitutionally. It's just live to fight another day. In all candor, part of the equation is life without parole until you get parole, or until the law changes and maybe you might have access to parole. And, it was interesting. I remember when we were in the Supreme Court in the Pennery case, the second Supreme Court case, Scalia, asshole, said exactly, basically that, well, you're just saying that, you want to get him off now, but if he has life without parole, you're coming back later, and you're going to say that a mentally retarded person can't have life without parole either. And, fine. We're here to talk about what we're here to talk about today. We're here to talk about the choice that's on the table today. And doesn't mean that, like with my formerly capital client in Alabama, we're going to have a hearing to say why exactly life without parole is grossly unconstitutional for somebody who committed a crime when he was 17. And it doesn't just have to apply to juveniles. I happen to hold that view, probably very similar views to you on life without parole, but you got to be pragmatic. You can't let your sort of values interfere with the very pragmatic decision that a client is facing, and they need all the information.
Yeah, let me just say this on top of that. One of the reasons why we're seeing this decline in death sentencing is that the country is rethinking on a much larger level how punitive the system became. Up until 1970, the line was flat about how many people were in prison, right? And then we just went crazy, and it went sky high, from 200,000 to 2.3 million. And it's only now that we're having to reckon with all these old people, very expensive prisoners. And so there's 1,000 forces that weren't in play 20 years ago, that very real forces, that for the first time in some of the toughest places in the country, as Barry has said, there's honest to good discussions going on. We can't afford this huge system. The wonderful victory that Christina got in the Supreme Court in the Buck case. Texas did everything to kill Dwayne Buck and put tremendous resources in. That case settled out last week for a sentence of less than life without parole. We had a very hard-fought case in Texas where we embarrassed the DA again and again and again. And when we finally were able to sit down with the victim's father and have a discussion about how can we sort of bring this to a conclusion. That case settled, not for life without parole, for something less. And so I think that you're going to see, I say this to my clients, as a lawyer, you have to understand that if you accept this sentence, you very well could be, this is death in prison. At the same time, you have to understand that you are, moments in time matter. You had a bad time, but there's all this re-examination going on. And lastly, I'll say, when the place with the highest incarceration rate in the country, and maybe even in the world, is Louisiana. Even Louisiana is rethinking in a fundamental way who needs to be in prison for a long time and who doesn't. And if it can happen in Louisiana, it can happen anywhere.
Let me just add one more thing on this subject, which is that the other thing that I think the Capital Defense Bar has done has led the mitigation movement, right? This is the group of people who created this idea and have pushed this idea that you cannot look at people limited to the crimes that they have committed, right? You have to look at them in a holistic manner, right? We have done the work, like it is from this community, that this idea of a multi-generational life history is required to understand, how someone should be appropriately punished. We are now in a box, you're right, where the options are death or life. But that story, right, and that pushing of information to make people look beyond the facts of an offense helps people understand that it shouldn't just be death or life, right? Those stories are powerful, and they really move people to understand, right, that that ridiculous binary choice that we currently have is a ridiculous binary choice, and that people that we represent are profoundly damaged people who had very limited choices and, ultimately committed terrible offenses. But it's not because they just, one day woke up and decided to kill someone, right? And so that work really does push the envelope past, this life, just life without parole or death, because we are, we have taught, right, the country and the world about sort of life history and how things affect people and lead them to commit crimes.
Okay, so why don't we take just a few more questions, and then we'll wrap it up. But let's hear, Ron, you've got your hand up, and you had your hand up. Yeah. You had the same question. Okay. Ron, go ahead.
I'm Ron Tabak. I think that lurking beneath the surface is something that was mentioned very briefly in passing without even saying what it stood for. The fraudulently entitled Anti-Terrorism Effective Death Penalty Act of 1996, which I didn't even give the name correctly, passed by that most empathetic of presidents, Bill Clinton. This is, were it not for the lethal injection activity, would prevent all of the things that Christina just correctly pointed out from being able to be brought to bear by post-conviction lawyers, because they are barred if earlier lawyers did not raise these things in state courts where they are underfunded. And the danger that I see is that since they are not being successful in clemency in most instances, that we could have a huge uptick in actual executions of people who, as George said before, would never get the death penalty in the first place today. But one of the reasons why these numbers are going down of new death sentences is the futility factor, the belief that we're spending all this money, but we have nothing to show for it in terms of executions. If they start getting executions, and you haven't seen anything yet, if Sessions is able to implement the worst version of the ADPA by declaring state capital punishment systems that are abysmal to be effective under the opt-in provisions, which would then make it even far worse. So, without trying to be a wet rag on this optimistic program, I would like to know, other than continuing the lethal injection phenomenon of stopping executions, is there anything that can be done, such as to make an argument that if evolving standards of decency means anything, It can't mean to execute thousands of people who we wouldn't be sentencing to death or even seeking the death penalty for under today's standards with today's lawyers, because they were sentenced to death under inadequate standards with an old system that we're not even using anymore. There has to be something to that argument, and I'd like to know what people think about it.
Okay, all right. Maybe, why don't we, let's see. All right, why don't we take that on? I mean, that had several dimensions to it, I think. One is the last part, which is really the claim about whether there's anything to the constitutional claim that it would be some kind of violation to execute someone that today we wouldn't have sentenced to death, right? But also in there, I think there's a larger question about the place of the effects of lethal injection on executions coming down, and to what extent that has contributed to these declining numbers. And on that, on either of those, Maya, you want to kick us off?
Well, just because you mentioned this, and it is, I think, something that I've heard Eric Friedman, when I first talked to him about lethal injection, he said, yeah, but it's a flash in the pan. And Clive, when I first talked to him about it, he was saying lethal injection was hopeless. And I get that. I think if we play it right, it doesn't need to be a flash in the pan. So I want to say that because we're all jaded when you do capital litigation. You do it, it's awful. But I think if we are creative, and I don't know everybody who's in this room, but there are different arguments that need to come to the fore now that we've got to where we've got to, which is a sort of apex in terms of the corporate engagement. You've got every single company who makes any FDA-approved execution drug saying they don't want their drugs used in executions and putting distribution controls in place. You've got track and trace systems coming into the fore. So they shouldn't be able to get good drugs, get good quality drugs without secrecy laws. Secrecy laws undermine contracts. How are we going to get the people who so care from the right, the Tea Party people, the libertarians, how do we get them on board to say, actually, do what you need to do, but don't undermine the interests of industry? I mean, that's just one angle. There's another public health angle to it. If you have secrecy, if you have compounded bad drugs come in, you're going to impact the health of patients as well. So sort of pulling these things together and forcing them into weighing it up, it's just adding to the cost of the death penalty, which is what we've all been doing and what this movement has done so brilliantly for decades. But I think that's very important. In Missouri in 2012, the governor, Jay Nixon, stayed in execution right before it happened in the interests of public health, he said, and then he removed propofol from the protocol. We don't know these ins and outs, but they actually do stop executions for a time, and then the brilliant litigators and the brilliant advocates and the brilliant spokespeople, who many of them are exonerees, they should flood in, and we should flood in, and we should push the abolition message. But we need, I don't think we should lose heart on that one right now, because otherwise we lose.
Okay, yeah, and I wasn't suggesting it's flash in the pan. It's had an amazing effect, right? It's had an amazing effect. The only question is whether, we've got two executions and possibly a third scheduled in Alabama, and there's still what's stopping it right now is lethal injection, but it didn't stop it in May and it didn't stop it in June. So it's had an amazing effect, but there are some possibilities that it might not cause the slowdowns as much. Now, but what about the constitutional claim then? Because I'm not very sanguine about it, but does someone think that there's much to the constitutional claim that you could argue it's cruel and unusual to execute someone if basically we wouldn't have charged them?
I think Ron is sometimes ahead of the game. I think there are people all over the country who are using that argument not in the court of law, but in the court of going to see the prosecutor and going to see the clemency authorities. And there are places in this country where there could be regular execution dates being set. And this is, I think, one reason why we're not seeing an uptick in executions in some places, where the governor is very unsympathetic because there is a lot of work going on. No one has sort of figured out a neat way to frame that as a legal claim yet. But rest assured, there's a lot of work going on there yet. But I think people have seen that more as something that you can take to, and that's what clemency's for, is that, is it just at the end for this sentence to be carried out? And there's been some real success already on that.
And I mean, the other element to this, of course, is the aging of the death row population, right? So aging and sickening of the death row population as it gets older and starts to have health issues. Okay, so we're I think we're actually out of time, but I do want to give an opportunity for any last thoughts to carry us into this evening and into the next decade of the death penalty. If anyone, Julia, are you going to give us the last?
Well, I don't need to be last, but I want to respond to Ron, because I think one thing we need to remember is, in the 20 years that I've been doing this, I think Ron Tabak actually helped me get my very first death penalty job with this guy right here. So thank you, Ron. But literally, in just that 20 years, things that were unconstitutional became unconstitutional in my lifetime as a litigator, and in 2 of my cases. I mean, not because of my work, but mental retardation was perfectly constitutional when I first started, and luckily in Atkins it became unconstitutional. Juveniles could be executed, and by the time my juvenile in Alabama was going to be executed, it became unconstitutional. So notions of retroactivity and EDPA and Teague retroactivity and all of that, you get a crack in the system, and what we're really good at is taking that crack and opening it wide up. And we can flip the law around, even on retroactivity.
Maya, quickly?
And you abolish in the US, you'll abolish in the rest of the world. So all the more reason to get on it.
And just to put more flesh on the bones of this, I know that Lincoln Kaplan, the journalist up at Yale, is doing a very interesting study of all the people that were executed in Texas, right, who actually had IQs that were too low and shouldn't have been executed, or mentally ill, to make your point, which puts that in the public mind. And when you're looking at the science angle, we had Texas, of course, was the first state to pass what we call a change of science statute. That if somebody is now saying, we get a recanting expert, or we say I would no longer go along with that, you can get back into court even though you would previously procedurally barred. Then we got it passed in California, and we're bringing these around the country. So I do think that one way of beginning to give this heft is almost demonstrating all the cases where people were convicted and sentenced to death based on bad evidence and based on the absence of a showing that, in terms of their mental state, that they ever should have been put in this position in the first place. So maybe that gives some life to it.
Last thought, Christina, and then George, and then?
I guess my hope would be, sort of as a last thought, that, certainly the people, I think to Julia's point, I think people in this room do take up this cause, that we have spent our lives fighting. There's a lot of work yet to be done around this issue, and I think that there's going to be times when it's going to be really, in the forefront of everyone's minds, and it's going to be times when it's not. And we need people, steadily, pushing this cause forward as much as possible beyond life without parole, right? Pushing it further and further. And so I just want to encourage, all of you in this room, to sort of join this effort, because it's going to take a while, and we need all of the help we can get, frankly.
Yeah, just real quickly. I've been at this for almost 40 years, and most of it was triage. Keep the numbers down. Save as many lives as you could. Those of you, the next 20 years is a great opportunity here to really sort of recalibrate this in a fundamentally good way. And so there's never been a better time to jump into this, because I think you can really make a difference, not just in individual cases, but on big policy stuff.
And I see so many of you out here who I know will be doing this work, or work like this, to make this a more just society. Present students and former students, Michael. So all of you, it's in your hands. All right, listen, I really want to thank our panel, Barry Scheck, Christina Swarns, Maya Foa, Julia Tarver-Wood, George Kendall. Thank you so much